All right, let's get started. This is the House Judiciary Non-Civil Committee. We've got several bills on the agenda. I'm looking around. I don't see Representative Strickland for the hopefully final on House Bill 845. Yeah, hope springs eternal, right? So let's do this. I see Representative Tanner. Representative Tanner has the companion legislative statutory piece for the constitutional amendment from yesterday. So let me recognize Representative Tanner on House Bill 870. Do we have any judges in the room? Judge, good to see you. Thanks for being here. Appreciate it.
Thank you, Mr. Chairman. I bring for you House Bill 870, LC 286856. And like the chairman said, this is the companion bill for the House resolution that you heard yesterday, which would call for a constitutional amendment to add reckless driving in to allow for the 10% surcharge to be collected for Brain and Spinal Injury Trust Fund. As you know, if that passes by the voters in November, there would have to be some enacting legislation done to allow that to be collected and to distribute it accordingly with the voters' wishes, and that's what House Bill 870 does. I'll be happy to answer any questions you have, but again, it's the companion bill to the House resolution you heard yesterday. And that was House Resolution 1183, just for reference.
Just to members, obviously I don't have a board here, so if you've got a question, just make yourself known in some somewhat subtle way, if you could. Appreciate it. Yeah, very subtle. Any questions for the author? Give me just 1 minute, Representative.
Yes, sir.
Thank you. Yeah, I don't have the constitutional amendment with me in the file, which is my fault. We've got alignment, obviously, with the percentage, the 10% of the original.
Yes, sir, we do. And I'd also, just to note, Jill's not the legislative council member that drew this, but she has reviewed it, and I asked her before the meeting if 870 was good, and she indicated she had reviewed it, and it was. But it does compare and is the same. Yes, sir.
Okay, we've reviewed it in terms of alignment with the resolution going about.
Yes, sir.
Okay. Any questions? Seeing none, are there any interested parties here to speak against House Bill 870? Any interested party here to speak against House Bill 870? Seeing none, what's the pleasure of the committee? Mr. Coomer moves due pass of House Bill 870, LC 286856. Second by Mr. Setzler. Are there any amendments? Seeing none, any further discussion? All in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Mr. Tanner.
Thank you.
Chairman Rice, are you ready to roll on the substitute to 671?
Mr. Chairman.
Okay, we're looking at LC 295990S. Just for members of the committee, this bill has gone through several drafts, redrafts, discussions, conversations, there are hearings. I think probably what would be the most efficient thing, Chairman Rice, I think we discussed it earlier, is to give us the high-level review on what the bill does, and then if there are any major changes from what the subcommittee saw when it considered the bill. That was through Mr. Setzler. So what I'll do is, not to be repetitive, we'll just have you go through the bill in general, highlight any changes beyond obviously structural or drafting and so forth, but high-level changes between subcommittee and full committee. Then I'll ask Mr. Setzler, subcommittee chair, for any additional report that he may want to give, and then we'll just go from there. Does that sound all right?
That sounds fine to me.
Okay.
All right, thank you, members of the committee. This is, as you've heard the LC number, you all should be there. This is all as a result of a study committee that was done on Title 40 for general revision of the provisions of Title 40 back in the summer of 2012, which your chairman was a part of with 5 other chairs. The first thing the bill does is to address the requirement that any pretrial diversion in any cases where the probationary sentence that includes a course requirement has to have an approved DDS course in terms of the curriculum. That's the primary measure in the first part of Section 1. The rest of Section 1, it's a long section. It has 11 pages. Actually, it's more than that. It has 13 pages in it. Many of those are definitional changes to the existing curriculum, and that's all they are. They don't make any difference in the overall portion of the bill. If you go to page 7, Section 1.11, you'll see the first reference to the major change in the bill, and that's the structure of the bill with regard to the fact that what we're doing and what the committee recommended was that for a .15 BAC or a refusal upon conviction on a first offense, the defendant would have to install an interlock device on their vehicle. And that is the first time it appears. It appears in that section simply because it has to do with a defensive driving course. It's also included in that section. That is the heart of the bill, though. The second thing I want to mention is in Section 2.1 on page 15. That is the driving without a license provision that's in the bill. There is a change here from the subcommittee, and that is that 40-5-121, which is the criminal penalty for repeat offenders in this area, is still in place. The prior version took it out. And it also says that if you're expired for under 31 days, that you're not guilty of the offenses on the criminal side on the 40-5-121. And this goes to the issue of somebody's got an expired license, like I'll admit that I did, and if I had gotten picked up, I would have been effectively charged under the 121 provisions. This makes clear that you're not charged in that situation, and so if you produce it, you're basically free, which is the way many prosecutors and solicitors are handling the situation right now. And it also provides that if you had a valid license but just didn't have it with you, it's the same situation. You're going to be excused.
Mr. Chairman, would you mind clarifying, just to make sure the committee is aware of what we did in a no-license situation?
Well, in a no-license situation, you're going back to the provisions of the criminal penalty, which is in the 121 section.
Right. As we read the code, the way the code was written was confusing. I think there have been 1 or 2 cases that have trickled up to the Court of Appeals. That notwithstanding, the code was unclear that if you were stopped and cited for no license, and in between the time of citation and your court date, you got a license, that some courts, if not many courts, were reading that to mean that that you're not guilty. Well, that's not consistent with the legislature's intent. No license is no license, and just getting it between the time of the citation and the court date shouldn't get an individual out of that situation. So I think we've clarified the statute to make that crystal clear, that getting a license between the citation, if you're no license, and I mean no license, not that you don't have it on you, no license on record with DDS, if you get it between the citation and the court date, that is not a mechanism to go ahead and walk away from the charge, and I think we have finally fixed that. I'm sorry, but I think that
thank you for those words. I appreciate the clarification on that. And I think everybody's agreed on the bill in terms of the prosecuting attorney's counsel and everything based upon those changes and a few others. Moving ahead to Section 3, this is the section that deals with the .15 and the refusals in terms of what happens if you're convicted in many different sections. Which I think what we all have to understand is that the DUI code goes through a lot of different sections, and so the choice was not to consolidate them, but to update those particular sections. That's why you find the same language throughout Section 3 of the bill. And basically, what this says is that what we're doing is I think I said it before, 0.15 or refusal on a first conviction, you're going to get an interlock device, and that's a mandatory interlock device. But the trade-off for that is that the limited driving permit for an IID interlock device is without restriction. So you'll be able to drive anywhere, but as long as you follow the provisions that are in Section 3. This applies to those under 21 as well as those over 21. It applies to, and you'll find the same language throughout the suspension section, revocations, and the one thing that most people are interested in, suppose they can't pay for the device. There's a hardship waiver. The industry has agreed that they will provide for the funds on a court-ordered hardship waiver to install the device. I think the important thing here is that there are about 3,500 of these convictions a year at this point in time, and they figure that they'll manage through that situation.
Can I ask a clarifying question, just
Sure.
since we're in that section? On a refusal, the page that we're on is that on a refusal, if the individual refuses the test, the breath test, and there is a hard suspension, they go the administrative route and they are given a limited driving permit for 120 days, that during that period of that permit there will be a mandated interlock device during that period as well. And the reason for that is that we didn't want to allow a refusal to be an end run,
Exactly.
a de facto end run around
Right.
accountability.
Nor did we want them to not have the opportunity to work
Right.
during that period of time.
That's right there.
And this is what I was reading and trying to make sure I understood right as well.
Thank you.
We can leave it out there. The suspension that we're talking about, I believe, would only come after conviction, correct?
Yes, right.
So, and I apologize for this, because when you say ALS or those proceedings, I want to make sure, because they're separate, and I just want to make sure I have a firm understanding of what we're doing. I think that I do, but the way that I see this is that you refuse, right, and you go to the ALS hearing. And again, I know we've said this a lot, but I just want to make sure that I understand this correctly. When you refuse, officer gives you 1205 form, you go to the ALS hearing. If that officer then says, well, I'll withdraw this suspension on your agreement to plead guilty, right? That's what happens every day. And the person will say, okay, I agree to plead guilty if you won't suspend my license. They'll get to drive without an interlock device in their car from that point until court. No interlock. Now, when they get to court, if it's their first one, the way that I understand this, once they plead guilty, because if they refuse, their license will be suspended. The only way they get a limited permit is if they go and get an interlock device on their car, and then they keep that interlock device in their car for 120 days. They would have a limited permit for that 120 days while they had the interlock on their vehicle. Then after that 120 days, they could then go and get their full license. Is that how this is going to play out?
I think it's still a 12-month suspension from the date of conviction.
Thank you for clarifying.
Is that
Yeah, on the criminal side. Yeah.
is that correct? Is that how it's going to work? Because right now the 12-month suspension gets reduced. You can drop it down to 4 months, which is 120 days.
Right.
So what I'm trying to make sure is that when the person pleads guilty, that's when the actual suspension kicks in on the first. And we're saying, based on this, is if you're above a .15 or you refused on your underlying charge of DUI and you're found guilty upon conviction, then for those people you will not get a limited driving permit until you show proof that you have an interlock device in your vehicle.
Yeah,
Once you show that, then you can get a limited permit that's good for 120 days. After 120 days, if you've done your DUI school, you're eligible to get your full license back. Is that what this is doing?
No. No, I believe the way we've written this, it's a 12-month requirement for the interlock device
On the first.
on the first.
Okay.
Yes.
Because that's currently now the way that it works, not on refusal, but on, and that's why I want to make sure we're getting this right. Currently, if you have a first-time DUI, and it's, I mean, it can be a refusal or it could be a breath test, whichever the case may be. Once you're convicted on a first time, you can get a limited permit the next day or whenever you're released from doing your mandatory jail time. And you can you can go and apply for a limited permit. That limited permit is good for 4 months. And then after that 4 months, you can go back, pay a reinstatement fee, and get your full license back. That's current law. That's what you can do now. So we are changing that requirement from 120 days for refusals and those above a .15 from being 120 days to a full year on the first one.
Yeah, first, I believe that's what we've been talking about
Okay.
throughout this.
Okay.
Yeah. If you're going to take the interlock device.
Because that's the same requirement we have now on a second. That's the same requirement we have now on a second DUI
Right.
after they've served a 4-month suspension. On a second and 5, the way it is now, they get a hard suspension for 4 months. Then they're eligible to get a work permit with an interlock device. And that interlock has to stay on the vehicle for 12 months. Just whenever we at first talked, I thought that this was going to be the same time frame as prior, which is 120 days. I just want to make sure that I understand what we're doing. So it is a full 12 months.
Chairman Wright, I think what the discussion was is that the trade-off was that this person could go to the bowling alley. They can go for 12 months to have the interlock device because they're not doing the limited permits. You were using the language limited permit, which represents a high tower, but what it is that there is no limited permit anymore. You're just suspended until you get the interlock device, and then you have the interlock device for 12 months, but you can go wherever
But you can go wherever you want.
Right.
you want. That's the trade-off
That's
with
what
the
we do.
language. For 12 months, though, it's not the 120 days.
Okay.
Right.
And so this will have no effect for those that are between, DUI conviction of .15 or less. This will have no bearing on that license.
You're 0.08, correct.
Or refuse.
So I mean, because we know you can get a DUI being less than a .08, you can have less safe or whatever. But anything below a .15, that person would go the traditional route, if you want to say that. And so that person would be eligible for a limited permit for 120 days, and then they get their full license after that.
Or they could opt to do don't we have language here? We've gone through a number of versions, so I want to make sure I'm clear on version control. They could opt to get the interlock device with a .09 conviction and be able to drive anywhere they wanted to, correct?
Yeah.
That was the discussion. I just don't know in managing the versions if that's what we meant.
I haven't looked through it. Is there an opt-in where they can do that?
That language is on page 21 of line 718 through 720.
Yeah, that's the implied consent portion.
Which line is she saying?
718 through 720.
Between that and then on page 19 of line 637 through 642.
Well, the way that I'm reading 637, and here I have no problems with this. I just want to make it so that someone could opt in. But 637 through 642, the way that I'm reading it, any person whose driver's license was suspended, I'm reading this as first time a person who was either refused the testing or whose blood alcohol concentration at the time of the offense was triggered, that triggered such offense was .15 grams or more, may apply for an ignition interlock device limited driving permit. And I guess that's where I was getting the limited driving permit language from. But it's saying that the way that I read that, I don't see where a person who's not one of those two could opt in. the way it's reading, you have to be one of those two to qualify.
In other words, the scenario that Representative Setzler mentioned about the .091.
That person would not be able to do that.
I don't think so. I don't, the way y'all have the versions before was 671 was traveling just on the concept of .15
Right.
would be eligible for this. Then the scenario came out that you wanted to add refusals to it.
Mhm.
And that language was massaged some from the department and some from
Mhm.
Dallas and imported here in the locations we were told. The scenario that you speak of now, I don't remember hearing anything about that, and I can't say whether it's true.
Okay.
What's the treatment of that person?
I was just, Representative Coomer asked what would be the treatment of that person. And again, that would go back, the way that I would assume this would work is that the person who's the .15 or less, or point,
109.
whatever, .1 or .149999 or less, they would be treated under the, I'm going to just call it the traditional way, which we have now, which would mean that that person would suffer a 4-month suspension. However, during that 4 months, they could get a limited permit. After that 4 months, they could apply to have their full license back. So I don't think we have an opt-in provision. I don't know if anyone's ever asked for it, but is that correct?
Well, the way we've always read this is upon conviction on a refusal or a .15. Right. I mean, that's what and anybody below that has the same privileges that they currently have in the law, not privileges, but the same
Yeah,
rights.
the only reason that I don't know if anybody would want to opt in, because, you're opting in for a 12-month requirement on you instead of a 4-month. However, you may have someone who doesn't want the restrictions that a limited
Right.
permit gives you, and they may say, well, hey, I'll
Right.
take the 12-month interlock device if I can drive wherever I want to. And I think if you look at your numbers, I think people who have to do that, it works. That's why we do it on a second DUI.
Thank you. We may be making this too hard. I don't see any reason, and the judge kind of walks through with the person what their limited driving permit conditions are going to be. And I don't see any reason a judge couldn't say, okay, you can drive anywhere you want to, but you're going to put on an interlock device to do it. I don't see any reason a judge couldn't offer that as a, is that practical, or is that just never going to happen?
As a practical matter, a judge can actually mandate an interlock device right now on a
He
first.
can.
Is that correct?
Yes.
So, as a practical matter, the individual can make that request, can they not?
But this is just saying they don't have a right to it. That was my only thing, and that may not be an issue. The thing that I was trying to iron out most of all was how long. Because at first I thought this was going to mirror the current situation, which is only 120 days. But that's different. We're going to now require this interlock for a full 12 months on the first time. And the way that I thought we were doing this at first was it was going to be to mirror the current setup, which is 120 days. So that's really where I was trying to go. I was trying to figure out what time frame we're doing.
Okay.
No, it is 12. It has been 12 months, and I don't think we've ever changed that.
Okay. Any additional questions or clarifications for the author on this particular piece? Not that we can't come back, we can, but just while we're here. Okay.
I'm just going to continue through this section 3 in terms of the high-level important items that I think are high-level important. You may not think they're different. Anyway, on 3.7, which is section 3.7, page 24, that's where what I'll call the hardship waiver is found, and that's where the court can find a hardship, and the IID provides for the paying of the interlock device. The next thing that I think is a high-level issue is the agreement between DDS and a provider. When you have an agreement with DDS to provide an interlock device, you're going to have to commit to that waiver in terms of, you don't get a license to be a provider unless you say you'll commit to the hardship waiver. The other provisions that are in here are primarily repeats of the language that you find on the 1.5 and refusal language. And I don't know if you have any questions on that or not, but I'd be happy to take any of them. I mean, we can go through this section by section if you want to within Section 3, but that is all changes to this with the same significance.
I think my primary concern is that we just have absolute clarity on, for members of the committee, that how we are treating, I think it's clear what we're doing on .15, but then just to roadmap again, out of an abundance of caution, the treatment on a refusal on a first.
Right.
And how we're differing. If we could probably just walk through that again, the procedure.
Well, the refusal is basically counts as a .15. It's the same thing. If it is a refusal, then you're going to get, if you're convicted, there's an abundance of evidence to do the conviction, as the solicitor has said to us in the subcommittee, then you'll go through the same process as if you were a .15. You'll have the opportunity for a limited driving permit if you complete the DUI risk reduction course, assuming that's required by the court, and then you apply for a limited driving permit interlock device after you've supplied proof that you've gotten the interlock device installed. At that point in time, it moves over into the issue of the check on an every 30-day basis with the provider to ensure that you are meeting the requirements of that. If in fact you don't, then the court has the opportunity to revoke your limited driving permit and the interlock device at that point in time. And that's on the basis of the provider providing the information that you've exceeded the legal limit. And I believe, I don't know that there's anything else that you can say, because it's one paragraph in each one of those sections that defines the .15 and refusal and what happens in that case, and that's basically what happens.
Questions from the committee? Mr. Sessler.
Again, this may be don't know who this is addressed to. I'll address it to the author. And again, there's been some movement on this, and I appreciate the author's willingness to work with the committee through the process. The person that refuses, when they leave jail and they want to drive, are they able to drive unimpeded between that point and when they actually stand for trial, or do they have to get an interlock device before they can get back out on the road? I was uncertain on that, and that may be to the
Chairman Rice,
Yeah, I'll be happy
how
to.
it works is, and Representative White House echo this, is that the individual is arrested if they refuse to test at the police station when they're offered the test. They'll be given an EDS form that essentially says, we're taking your license, but you have a 30-day permit. It's a pink piece of paper they drive around
It's
with.
1209.
It's a 1205 form.
1205.
EDS will then set an administrative license suspension hearing in front of an ALJ. At that point, then the officer and the defendant will have to request the hearing within 10 days of their arrest. If they request the hearing is set down. If not, the person suspended, the license is suspended as administrative suspension by consent.
immediately, yeah.
At that point, they can go, as Representative Hightower said earlier, they can go to that hearing, have a negotiation with the law enforcement officer to say, okay, will you withdraw the ALS suspension and allow my guy to drive to go to court in the criminal case? So you actually have two suspensions running here. You have the implied consent suspension, and then what we're talking about here is the actual criminal suspension after a conviction. So there won't be an interlock device until after a conviction in either state court or municipal court or superior court or wherever the court or the jurisdiction of that offense is held.
tell us is this intended to, or will, by this language, will this provision apply to the pre-conviction arrestee who is subject to the administrative suspension?
I don't know the answer to that.
Thank you.
Mr. Chairman, and I raise that question. This is, this is where we separate out what happens today and what's proposed. I just want to make sure there's clarity, because there has been discussion throughout this process that before somebody gets back on the road, they have an interlock device to get back on the road prior to conviction. Okay, that's been on the table in discussion. That's where my question is where we land, where this language lands us. And I confess, Mr. Chairman, that I've taken my eye off that ball in the last 3 weeks. I personally, from a policy standpoint, have no issue if somebody refuses. There's a profound inference against them that they're a .15 are going to be treated that way moving forward under law, administratively and otherwise. To say that you've got to have an interlock device before you get back in a car 3 days, 5 days, 10 days after you get out of jail, I don't know that bothers me. If we think it's the public policy of the state that this protection apply for a year, why shouldn't it apply immediately after the infraction happens? I don't know that's, I wrestle with it. I'm just, I do think, to the chairman's point, we as a committee didn't have confidence of what we're doing here and what we're not doing. And I don't know that I contribute much to that effort. But I'm certainly going to dig back into this, Mr. Chairman, and make sure we have a
Well, the issue is it's coming down, as I understand, it's distilling itself down into has to do with upon conviction.
Yeah, right.
Right? I mean,
That's right.
Is that not what this is, the potential, the issue is, of course, the treatment with .15 on the mandatory interlock is upon conviction. And
Correct.
The treatment on the refusal and the mandated interlock is also upon conviction.
It is.
Ultimately upon
That we
conviction.
know for sure, yeah.
There's I want to say there's a consistency there. I know that those are different processes. But I'm not trying to put words in your mouth, but my sense is that consistency was the intention of the author. Is that a fair statement?
The intention is consistency between
Okay.
refusals and .15 convictions.
Mr. Coomer, let me redirect over to you. Would you care to speak to that or concerns about
Sure.
it?
And I'll echo what Chairman Setzler said. Frankly, I don't have a problem if it applies immediately after the DUI arrest and before the conviction. I just don't want to not know. I don't want to have any uncertainty about what I'm voting on.
Sure.
And again, 705 to 724 clearly says this applies if a person under arrest, and then it says for DUI refusal, and then explains that the law enforcement officer submits the report and the suspension occurs administratively, and then we have the language that says that they have an automatic suspension unless the person provides proof of the installation of the ignition interlock device. So, I mean, look, as a policy matter, I'm fine with it if it applies. I just want to get a consistent, because there are two people said it didn't apply immediately after arrest, but the language of this bill says it does apply immediately after arrest. I just want to make sure we're all on the same page with whatever the vote is.
Okay. Who is...
You can go to the solicitor if you want. This is the license suspension section, and I mean, to me, it clearly says upon first suspension pursuant with the previous suspension is obtained for 1 year, no sooner than 30 days following the effective date, which is at the top of 22. Person may apply to the department for early reinstatement of his driver's license, which was the intent. We want people to have the option.
Where are you?
I'm on page 22 at the top. My line number is cut off on my copy, so it starts at 733. May apply to the department for early reinstatement of the license, such like reinstatement, the proof of the DUI alcohol abuse reduction program, And then it continues on down on the 742. Provided, however, that any driver refuses testing who is black or is .15 shall not be eligible for earlier license unless and shall remain until such provides proof of installation on 746 of maintenance of an ignition interlock device for a period of time consuming the issuance of the interlock device limited driving permit. So, in what we all wanted to do was to have an option for people if they were suspended, which is the administrative procedure, to have the option of taking an interlock device. And then moving on, and then the criminal case would, if it's a .15 or if there's a conviction for a refusal of .15, then they would. What I can't point you to is the fact that time on the interlock device in the suspension counts against the 12 months or not. I don't see that. I can't refer to it.
I might be able to provide a tiny bit of service. It's not full. But, so, what's the difference between the sub y'all had where you were just talking about .15 and an interlock, and what's the sub that you have before you now? And the difference is two things. One is repeatedly through the bill, and I'm looking at page 23 just because of the string of workings. Is language is consistently added. I'm looking at page 23 at line 788, for which such person refused testing as required by code section 40-5-67.1 and 40-5-153. 153 is the requirement that a commercial driver submit to testing, and 67.1 is the regular driver submit to testing. So that refusal language was added. Everywhere you saw the .15. The only other place that language was added that was relative to this issue is in section 3-4 at lines 718 through 720. Those are the changes. If that doesn't accomplish the purpose, I just wanted you to know what was done to get where you are now.
And Mr. Chairman, to counsel's remark there, I hope this clarifies. I'm reading on line 709. Upon receipt of report of the law enforcement officer, this is page 21, line 709. I mean, what I'm reading here, this is, I think, addresses Representative Coomer's concern. I read the chain of events here. This is basically upon arrest. This is what happens upon arrest for these circumstances. Upon receipt of report of law enforcement officer, reasonable grounds to believe the arrested person had been driving, or was in, and you read down, or that person had been driving. As you step through this, the department shall suspend the person's driver's license, permit, or non-resident operating privilege for 1 year unless the person puts on an interlock device. So as I read this, section 3-4, and I'll read it again, and I'll read it again before we vote, Mr. Chairman, but I read this to say that it's this part that says you have an interlock device if you're going to drive between when you're arrested and when you're going to go stand in court. Is that correct?
The only difference between the rest of the bill is that if you refuse the test, you can get an interlock device after the ALS hearing. But if you're a .15 or higher, which is the rest of the bill, if you're a .15 or higher, you can't get the interlock device. It's just a refusal, serious injury by vehicle or fatality compared to that code section. But that 67.1 subsection D is the ALS suspension, which Representative Coomer pointed out. That is where the ALS suspension is triggered.
And by putting this interlock provision in the ALS suspension piece, that's prior to court, correct?
Correct.
Yeah.
I think section 3.4 deals with implied consent, and then the next section, 46 through 91, deals with the other issue.
One more question for the author. Is it your intention that a person who has a DUI refusal would have the option to have the interlock device and then be able to drive with that interlock device before they're convicted?
Yes.
Okay. I think that's what the bill does. Thank you.
If they're not concerned that, because I know right now what happens is ALS is sometimes you get these people to agree to plead guilty because they want that driver's license, right? And then they have to this allows them on a refusal to get an interlock device, right? And start driving right then, right?
Correct.
Are the prosecutors and others not worried that people will now say, okay, I can fight the DUI, now I can get this interlock device. So now on refusal, instead of helping settle these cases, which is what happens in ALS hearings, are you concerned at all? Might as well, I see out here this question, are y'all concerned at all that people will now say, I don't have to weigh that balance so much. Now for those who have money, who have the resource, they can go, well, I'll just get this, I get an interlock device, all right? Go ahead, keep my, keep the suspension, because now I have an out. Now I get to go and get an interlock device, and I can get it's not a limited permit or anything. I can get a limited interlock device in my car, and I can drive wherever I want for the rest of the time.
Speaking of
Is that a concern?
Chisholm, it is a concern because when we were looking at this bill, the version that came out of subcommittee that had the repeal of the search warrant issue, didn't really pay attention to this until Representative Cooper pointed. But that is a concern because you and I have dealt with these on an adversarial basis, and that's one of the ways that we resolve a lot of our DUIs, because if we do have that refusal, it helps us resolve that DUI. The guy wants his driver's license back, he can get rid of the LS suspension.
And I see where y'all are saying y'all are fine with it being before conviction. I'm fine with that too, no problem. But we may be taking a very significant tool away from the process of getting the vote. Because at ALS, a lot of these people will weigh the decision. Is it worth losing my license, or is it worth fighting the DUI? And I'll be honest with you, most people will say, I need my license. I got it. I got to provide for my family. So they'll go ahead and agree right then to plead the DUI. But what this will allow, the person will go, all right, I'll plead the DUI. Well, actually, I don't have to work for that officer anymore. You know what? I'm just go get an interlock device tomorrow in my vehicle, and I'll drive. Keep driving. So sure, keep my suspension. That's fine. I'll get an interlock. I'll have a way around it. They have an interlock in their car, but they're no longer put in a very tight fix. That's what you're saying, though, right?
They're no longer leveraged. They can go ahead,
They're right.
drive, go to work,
leverage-
lead their lives while they potentially fight the underlying charge.
And I'm just making sure
Maybe,
that's-
maybe not.
that's the policy that we're
As opposed, as opposed to being leveraged into a decision they may not actually want
Yes, because
to
right
make.
now, this is a tool that law enforcement can use to leverage people to plead guilty. And I just want to make sure, because the way that I'm reading this, now that Representative Coomer has pointed that out, I just want to make sure that's the policy that we're going to make. So since Coomer brought up that, we need to talk about that, because that is definitely a leverage tool that will no longer be there. And it's definitely one law enforcement uses.
If I might, since you asked Matt's perspective on that, we're not really concerned about whether or not you're leveraging their conviction or not. We're concerned about making sure they're not driving drunk. We know that license suspension isn't a stick at all, because 75% of people are driving on a suspended license anyway. So there's no penalty there. You're not putting them in a hard spot. So if we're going to let them drive anyway, well, we're not letting them drive anyway. If they're going to drive anyway, why not have the ignition interlock device? At least then society knows that while they're driving, we're safe.
When you're putting the law-abiding citizen in this spot, I mean, of course, you're now going to have to break the law, but the law-abiding citizen, which we try to look at as people who will follow these laws, this is definitely taking away a tool. But I mean, I'm fine. I think this is fine. I just make sure that we.
You've expressed the struggle, I think, pretty well. And there's the push and pull there. There are the tools of safety on the road versus the leveraging tool that the gentleman spoke of in terms of securing a conviction on the underlying charge. Both of which are huge considerations.
I just know that when you take some of this leveraging tool away, you're going to have people that will choose to fight more DUIs in court, I believe, because they'll have the opportunity to, without having to lose a license permanently.
Provided that they go the interlock route. I think there may be an issue there with regard to, some people will see that as just not a big deal. Some people, I think, will see that as the scarlet letter and will want to avoid it.
Yeah, that's true.
That's just going to be a highly individual case-by-case basis, I would think.
I think that what we're doing here, the policy standpoint is fine, because I don't mind the interlock being there at all before. I just wanted to make sure we knew
Okay.
what.
Mr. Chairman, did you, that was good discussion. Mr. Chairman, did you want to cross the T on that, or anything more you wanted to add?
Well, I think, look, I mean, we've discussed this several times in terms of the behavioral changes that come out of interlock devices. We know that the recidivism rate drops based upon the results of the other tests that have done in other states. There are multiple states that do similar things at this point in time. We also know that there are at least 33,000 driving without a license convictions every year that the department gets. That's probably, by all reports, a minuscule number compared to the number of people that are driving without a license. So this whole process is one that's open to a lot of different, individual behavioral approaches, and all we're trying to do is to put it in a box, basically, and say, okay, here's the opportunity for you to do this legally, and to hopefully help to change the behavior.
Let me ask, any additional follow-up questions from members of the committee for the author?
I do have one, Mr.
Yeah. Again, walking through these set of conditions, so I get it for the refusals. I want to make sure we can find and put our finger on if someone actually chooses to blow, and they blow a .17, what's their life going to be like between when they walk out of jail and when their court date is? I found it for the refusals. I'm trying to find it for the .15s here.
I think that's in the next section, section 3.5.
Okay.
Which also deals with suspensions, not convictions.
It's the same thing. It's a .15.
67.1, right? Yep.
They are eligible.
Yep. Got it. Thanks.
Let me ask, is there any individual or
Entity that would like to be heard in opposition to House Bill 671? Any interested party would like to be heard in opposition to House Bill 671? What, is there I know there were prosecutors here. Are you representing the Prosecuting Attorneys Council in your appearance here today?
Yeah, C.R. Chisholm, Solicitor General, Clark County, President of the Georgia Association of Solicitors General. I have a number of colleagues who are here. Matt Kroll, who has already spoke, Solicitor Douglas County, Rebecca Grice and her assistant, Shay Young from Bibb County. We also have Todd Hayes from PAC. We have Jessica Moss from Solicitor from Cherokee County, Sandy Weisenbaker from Coweta County, and we also have Carmen Smith, Fulton County. And we came in support of the bill. We also know that it's been through an evolution at this point and through many different forms, and we support it in its current.
Okay. Thank you. I just wanted to check on that because it has gone through several iterations, and we didn't want to make any presumptions on anything. Okay. I don't see any party wanting to be heard in opposition to the substitute on House Bill 671. What's the pleasure of the committee?
Move to pass.
Mr. Coomer moves due pass of House Bill 671, LC 295990S. Is there a second? Second by Mr. Setzler. Are there any amendments? Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Chairman.
Thank you to the members of the committee, and thanks for the learned attorneys and non-attorneys' opinions.
And survived notwithstanding.
Arduous, but it's been good. It's been good.
Mr. Strickland is now here for the third act of a three-act drama on House Bill 845.
Shortest of the act. Mr. Chairman, if we needed to, we could amend this bill.
845? Yes, we can.
No, 671.
671, yeah. I dare you. If we could have order in the room, please. This meeting's not over. Thank you so much for your consideration. House Bill 845, Mr. Strickland.
Thank you, Mr. Chairman, and I won't turn the mic on unless I need to avoid any other issues with that. The
if you take a look at the substitute 2959886S, this is a sub as a result of working with GACTL, Sheriff Association, PAC, members of the press. This is the, unless we're told otherwise today, the version that we have come to that have agreement on. The changes that we made from yesterday, we're trying to make sure that when a sheriff needs to or has to still release some mugshots when we post it online, that they'll be able to do so. We're not trying to take any of that right away. And so if you look at lines 15 and 16, you'll see the changes from yesterday. We listed out Title 16, Title 40. We listed out the state sexual offender registry, and also 501817, which I believe it should be 77. And so the only change that does need to happen is that one needs to be a 7, 501877, which is the catch-all, if you will, that allows the release of photograph where there's a criminal investigation to law enforcement, to a grand jury, and several other folks listed in that code section. I believe after all this bill has been through, this is a great bill that's a balancing act that protects the right, as I keep calling it, of the legitimate press to still publish images where they need to do that, where there's a public interest, but we are drastically cutting off the supply of these images without burdening the sheriffs and without putting too much burden on the press folks who work with me very well in this bill. So I'll be happy to take any other questions anybody has, but ask your favorable consideration of this version of the bill.
Just to be clear, beginning on line 15, there's nothing in the bill that would defeat the purposes of requirements set out in Titles 16 and 40 with regard to the sex offender registry, so that we're removing any possibility of a unintended consequence there. Is that a fair statement?
And that's fair. Just for the record, the bill never did that. The original drafts required once their conviction occurs, the original draft of the bill, at that point all the mugshots be released. Right. So there never was a version of this bill that didn't allow the images to come out in this situation.
Okay. Questions from members of the committee on 5986S?
Can law enforcement refuse to provide photographs? Like, for example, if I know we certify now with a bill, if you're going to publish online, you're saying that, and you're not going to charge for removal.
Right.
And if the sheriff suspects that this person's not legitimate, does he or she have the discretion to refuse to turn that electronic version of the bill?
I'll defer to legislative counsel, but I'll say this. Section 2, my understanding is we are not excluding mugshots or arrest photos, we want to call them, from records, the Open Records Act. And so it would fall back to the Open Records Act, and they would still have a right to those records at that point. If Ms. Travis wants to speak further on that. That is not the intention. The intention is there is a right to the release of these images that we currently have, and there's nothing in the bill that says it can't be released. So I guess I'm answering my question away. We're not changing anything as far as the right to have them released. We're adding the requirements we have to do to get them. So as far as actually when I can get them, that right still exists. That makes sense.
The concern I have is since we're allowing them to, I guess, submit the statement electronically, and like if somebody, if these are what I would consider extortionists, right?
Mm-hmm.
Charging people from, I don't suspect that they're going to have any qualms about lying to the sheriff about their intentions.
And it may not. This will make it harder, though. This will make them put it in writing the request. I believe and if we don't see a reduction in the mugshots that are posted on these websites, and we can say this didn't work, and they were getting these mugshots another way. My understanding is most of these images are coming out because sheriffs are voluntarily, which they probably need to do right now under law, putting every mugshot online right away, and that's where these images really come from. They're capturing those online photos, and this is going to stop that. So we're making it or at least making it harder. So we're going to know who's requesting, the local sheriff will see who it is requesting these images.
Mr. Pack, you may have touched on this question. It was a question that I actually discussed earlier, submit a statement affirming. I'm just trying to step through the scenario of one of these entities that we're trying to combat. And Ms. Pack, I apologize. You may have already, I was distracted, may have already had this line of questioning. If they could make the request electronically, and if law enforcement could receive it electronically without having to have the piece of paper, they're much more likely, I agree, to go ahead and do that. That goes to the issue of whether law enforcement would receive it electronically. There's something here preventing them from receiving it electronically. Is that correct?
That's right. That's right. And if we see the problem continues, we might consider amending and making it where they have to be released somehow in person. I don't know, but I think that if we do this, I think we're going to see these companies go more to our states, and because I think the companies are not doing a lot of work to these images right now, and this at least requires one step of work in our state to get them.
I think this is a good step forward. I fully support that. I look at it, like I believe websites like any of the hire somebody will get the documents. So the person getting the documents, I'm in Georgia. I want to make some money. So I'm square saying, look, I'm not going to put it on the website. I'm not going to charge for removal. So once I get these images, I'm going to sell them to TNT or whoever. Then we have a big loophole, right? I know it's an additional step, but I'm just saying, since we have the bill here, I'm wondering if there's a way we could tighten that to prevent that.
And we could, but we're going to get more and more restrictive on our press, and that's the policy statement we have to make here. And like, you know, the original draft said that until there's a conviction, the mugshots just don't come out, basically. And I think there were concerns about that being overkill, and it may be. This step here may be enough to prevent it here in Georgia, at least prevent most images from coming out. But if we learn that it's not, then we could go back and address a stricter bill later. I think this is a great step. And looking what other states have done, some states, I was incorrect and said this 2 days ago, remember I originally brought this bill, but some states have gone further. But we will be in the top 5 as far as in the country how far we've gone by passing this measure, I believe. And addressing these images. So I think it is a step in the right direction, and it may accomplish our goal without having to do overkill here.
I may, and I've talked to the author. I may be violently agreeing with the gentleman on the issue. I just, for context, I'll make it quick. I mean, there are websites today, and I've got 5 of them, thejailreport.com, georgia.arrest.org, Mugshots Online, and bustedmugshots.com, that put these things up there, and they have advertisements around them. So when you drive traffic, that they accrue their revenue, their business models through an advertisement model. I mean, if one of these went around and got all the mugshots and put them online, and one of these, what I'm calling the bad actor, that wants to have you pay them to take them down, goes on the website, pulls those, and puts them on their site, then they've completely gotten around the way the law is constructed. If we have existing websites today that file open records request and post these things up, and don't accept money to pull them down, they're just putting out, they're out there, and they've got what is a sustainable business model today, means they can support themselves, continue to do this, then it just becomes an intermediary for the bad actors to take from their website and post and then charge you to pull them down. I don't know that we've got I strongly support the gentleman's approach. The old fortune favors the bold approach to this. I don't know why we're backing off of something that's going to get our arms around this issue. I think it's a real issue. And so I guess, Mr. Chairman, I'm prepared to support the proposition, but I don't know. I guess I'm calling into question the effort. If Kansas, mugshots or criminal investigative records and public disclosure is not required, Louisiana, South Dakota, Texas, West Virginia. I mean, these are peer states that we would use as a basis of comparison, where that's the case. I don't know why we're loosey-goosey with these records, particularly when you look at the damage and the harm that can come from them. So I just, I don't know why we're I mean, the gentleman's bill might get opposition from some corners, but I think to accomplish his goal, I think you weather that storm and get it right.
You can respond if you want to, but you don't have to.
I'll just say, I hear you, but this will still, the exception of states that you mentioned, this will put us in the top of the country as far as with restrictions on it. There are legitimate times images should come out, and there's some concern I have of what those other states have done too. Because you look here, how hard we have to work to make sure we still have these exceptions in our bill, to make sure sheriff can still release them at times. So I hear you, but I think we see if we can accomplish this without having to completely not allow to release these images.
Mr. Coomer.
Just real quick, do we have any, is there any evidence about what the result has been in those other states that have already passed this similar legislation?
No, it'd be really hard to track. Until you start getting individual stories, I guess it's going to be hard to track that, but I have not seen any studies on that.
What about?
Thank you.
Just for his discussion, the author. What if we add the words after the word in line 21, or transfer to publication? So you're swearing that you're not going to post or charge for removal, or transfer to a website that's going to do that. So that kind of somewhat limits. So if you're getting it for a purpose of the third party, you're swearing that you're not going to do that, knowing that the third party is going to charge for removal of the mugshot. And I'm just saying, I understand that's a change on the fly, I guess, but
well,
can you say that again?
sure.
And I'm concerned with, Representative Pack, that I don't believe that these entities would be transferring to the bad actor. I think it's a passive. They post them, they're grabbed and pulled down. I don't think it takes any action of theirs to allow that to happen. I think the issue is that prior to conviction, there's a major negative impact that accrues to people who are arrested. And this gets back to the record restriction bill we've worked on for the last 3 years. Prior to being convicted, you receive a sentence, you receive a punishment. There could be financial, it could be reputation, it could be a whole lot of things. Pre-conviction, you're being punished for something you're simply charged with. And this public records is a dimension of that fight, and photographs is another dimension. And if we allow it to happen, then we're allowing the public to be damaged as a result of us not providing definitive guidance in law that people's mugshots are protected until they're convicted. If we want to make it available upon conviction, fine. But what we're allowing to have happen by being passive on this, the General Assembly is saying, before conviction, perhaps you're subject to be acquitted of aggravated child molestation and sexual battery, all these awful sounding things the public hears and shudders at. You're going to suffer the penalty of being accused of this, because we're not locking down and protecting your identity through the process until you're convicted. And I think it's our duty. And I think it's the gentleman's intent. It's great to get our arms around it.
And I misspoke, Representative Pack. Section
What's the pleasure of the committee on HB 845? Mr. Ramsey moves due pass of HB 845, LC 295986S, second by Mr. Pack. Are there any amendments, Mr. Pack?
Line 15, I think that's 17, should be 77. And on line 21, after the word website, before the semicolon, insert or transfer to a person to be placed in a publication or posted to a website.
Say that one more time.
Or transfer to a person to be placed in a publication or posted to a website.
Transfer will allow for transfer.
Any questions on the amendment? Are there any questions on the Pack amendment, Mr. Setzler?
I mean, Mr. Chairman, to the Pack amendment, I mean, I think I understand the gentleman's intent, I believe. But if someone doesn't actively transfer it, but their actions allow it to be transferred, or they have plausible deniability, hey, I didn't transfer it, I didn't send it to his website, but I put it up here in the public space, which makes anyone be able to get it. I mean, I think it has the same effect.
But if that person's not receiving a financial benefit, that kind of takes it out of the whole purpose of the bill. I mean, trying to allow people to get stuff, but not get it in a way that they're going to get enriched from somebody else's arrest.
No, that was the point we made about the websites that don't ask people to pay to take pictures down. They post they get the pictures, they post them to a website, they have advertisements on their website, that's their business model, and they just sit up there. And they become the honeypot for these bad actors to go pull all the photos they want and pull them to their website and charge to have them come down. What we're doing is we're allowing this honeypot to happen, and that's Representative Gravely's making fun of my colloquialisms here, so I'll add to the string of them. But I mean, you've got this big pot of photos, and there's a business model to support it. And unless we create some kind of duty to not allow it to happen, then I mean, I think it's just I don't know that the Pack amendment accomplishes anything.
Well, I think you can only allow somebody to take it. That's sufficient. I think you'd be able to do that and prosecute it with a false statement. If your intention is to post it on your website knowing that you're going to make some money and that somebody take it from you, I'll defer to the prosecutor in the room, but I imagine you can make a case like that.
The language is may, so it's may be placed in or may be transferred to, and I think that's...
I mean,
we're trying to tie down what statement that they need to affirm to the sheriff. Not necessarily that trying to come up with a scenario where every single case could be prosecuted.
I mean, perhaps an approach is that whether you post it to a website and make people pay you to take it down, or whether you post it to the website and accrue some kind of advertising revenue from it, perhaps those ought to be treated the same way. If you monetize the posting of pictures.
Let's go ahead and act on the Pack amendment. We can continue to look at it. Doesn't preclude a floor amendment if absolutely necessary. Is everyone clear on the Pack amendment? All in favor of the Pack amendment signify by saying aye.